introduce Mr. Advani, who, and I asked him when I met him, are you Mr. Advani of Advani and Co? And he said, yes, I am. So I don't think it needs any introduction. So he is, known to most people who deal in law and practice law here. And the interesting thing is that this is perhaps the only panel where we are having a discussion beyond what we've discussed thus far today, in terms of everything else was to talk about the general counsel's roles and about how we can run our departments better and stuff like that. So this is the one where, I guess, prompted also by a recent Supreme Court judgment. So over to you, Mr. Advani, to take it over.
Let me first take a quick opportunity to introduce my fellow panelists. Their biographers are all there in detail. The biographies are in detail. Our first speaker is going to be Ruth Stackpool, who is qualified in the UK and in Australia and studied in Australia, and now heads the HKIAC, which is the Hong Kong Centre of International Arbitration. Our second speaker is going to be Vivekananda, who is now presently the head of SIAC. All our qualified lawyers all have significant arbitration experience and are not merely institution heads, but actually run the institution and run it most efficiently. And our last speaker is Ajay Thomas, who is the head of LCIA India, and he will tell you all about the distinction between LCIA India and LCIA in London and why they felt it necessary to have place in India. Dealing very briefly with the topics, I think that most of us are all entirely familiar with the problem with Indian arbitration. Essentially, our arbitrators are all retired judges, all very eminent, but essentially try and run it like a courtroom, run it with large amounts of adjournment. Because of the number of parties involved, there's no sensible running of arbitrations. They're done completely piecemeal, run over a large number of years. And on another front, and where we're going to look for support of all the general counsel, because most of us who are arbitration practitioners are equally fed up of it. I'm sure the general counsel are even more fed up of it, but we're entirely fed up with the process, so we recently launched the arbitration bar. The arbitration bar consists of most of the large law firms that joined. Slowly the senior counsel, the junior counsels are all going to join. And the idea is not to be a rival institution to the three institutions in front of you, because we will not administer arbitrations. All that we will do is we'll suggest best practices, we'll suggest a fee structure, and at some point in time we will suggest arbitrators who are non-retired judges, who will try and, as far as we are concerned, adhere to best practices and try and move the arbitration with some speed and with some efficiency and in a cost-effective manner. One of the issues here, which unfortunately I think none of our panelists are qualified to speak, is on how do you select an arbitration law firm. This is going to be of a concern to in-house counsel, because I'm sure they've all tried various law firms, some with a huge amount of success, some maybe not so successfully. And the standard pattern has been to engage a law firm, then engage a senior counsel, engage a further junior counsel, then try and coincide all their dates and try and get hearings. And we can see it's all not worked very efficiently. The more modern practices coming from overseas is that to engage a law firm to do everything. They sit, they argue matters, they've had experience, because most of the lawyers that we have today, the seniors in the country, really do not have trial experience. They're either appearing in the Supreme Court or in the high courts. Several high courts do not have original jurisdictions. Some have original jurisdiction, but how many of them have trial experiences? They're doing writ petitions, they're doing constitutional matters, company law, but with very little trial experience. So the experience globally has now been found to engage law firms to do everything. The work is very intensive, especially when you're doing international arbitration, and hopefully it'll become a domestic arbitration over a period of time, and requires a team effort. It's not a one-man show anymore. The workload is just too much. So if you have a sensible team with various law firms, and over a period of time, law firms are building this, and that's how it's going. One or two of the issues I am going to request our panel to try and address, if they've had experience with it, is more and more because of how expensive international arbitration they become. There's a concept in some countries grown of third-party funding. Basically, venture capitalists, who seem to be everywhere nowadays, will fund the litigation, including the arbitration costs, the lawyer's costs, the cost of expert witnesses, for a piece of the action as and when the party that succeeds wins. It's not done on a benevolent basis at all, because what they'll do, they'll evaluate the claim, make sure your claim is absolutely first rate and top class and a very good chance of success, and then they will fund it. The other issue that does arise in several international law firms, international arbitrations, is the question of interim orders. How do you protect the fruits of the arbitration so that at the end of the day it just doesn't disappear? And where does it go? And the last issue, which again is increasingly important, and in the first recently our Supreme Court addressed it in that Chloro Plus judgment, is how do you rope in non-parties to an arbitration? Because very often a very small subsidiary is the signing party. You can win the case, you can win the arbitration, it may be a $1 company and you'll recover nothing. So how do you put the parent bodies in, or in construction contracts, if there is a main contract and a subcontract and the subcontractors are at fault or it's a mixed fault, you cannot determine who, do we have to do multiple arbitrations, or is there a way of roping them in? Our Supreme Court recently, in a very recent decision, has dealt with the topic, and I'm just wondering if any of the institutions deal with the topic. So with that brief introduction, I'm going to ask Ruth, as our first speaker, to talk about the Hong Kong IAC Center, to give you some highlights of the center. And to my mind, each of these institutions have worked exceedingly efficient, and all of them are exceedingly successful, if a little competitive at times. Thanks.
Right, I'm just going to have some slides up while I'm talking so that you can just see some of the things that I want to talk about. Really, I just want to give a bit of an explanation as to why Hong Kong is a viable option for solving your disputes if you're looking to do an international arbitration. I think until recently, it was considered that Indian parties didn't really have that many options. And actually, I think since 19th of March last year was really when the scene opened up for Hong Kong. And that was because under the Indian Arbitration Act, you couldn't have your award enforced here unless the government had gazetted where the award was rendered as a New York Convention jurisdiction. So until that time, until last year, China wasn't gazetted, so any awards made in China or Hong Kong could not be enforced in India, which obviously was a big problem in how we could, actually effectively promote ourselves as a place for Indian parties to arbitrate. So now that that's changed, we can actually come out and I can show you some advantages of why Hong Kong really is a very good option if you're thinking about doing a foreign arbitration and having a clause in your contract. And this notification came at a really important time. There's been a huge growth in trade between India and China. You can see up there the figure for last year, for 2011, was 73.9 billion, which was increased by 12.2 billion from the year before, and this has prompted some dialogue between the two governments, and they set an expectation that perhaps by 2015 that figure might be raised to 100 billion. But actually the way things are going, it's actually likely to happen this year. So obviously as these economic ties strengthen between India and China, finding a venue where you can resolve any disputes that might come up through these greater economic links is going to be really important. Just as an aside, this is something that you really need to think about well in advance of signing a contract. Where you choose to arbitrate, what rules you choose to apply, can have really serious consequences, and often if the clause is inserted really at the 11th hour of negotiations, it's you can end up in places down the track if a dispute does arise that you really didn't intend. So anyway, if you are thinking about where you might want to arbitrate and you're negotiating a contract, why would Hong Kong be a good place to go? And what makes it an attractive venue to have as the seat of your arbitration. So first of all, as it says, it's convenient, it's reliable, you have a huge pool of expertise there, and it's all within a sophisticated and very pro-arbitration legislative and judicial framework. Also, in particular, Singapore is traditionally thought of as a very good option for Indian parties. If you happen to be doing business with a Singaporean company, you obviously would like not to go to Singapore. So with the rise of Hong Kong, it presents another option. So in terms of convenience, why Hong Kong? Well, fairly obviously, it's, you can get there fairly easily from here or from Delhi. There's direct flights every day. Hong Kong's also linked to 150 other destinations in the world by direct flights, so whoever you're dealing with is likely to be able to get there very easily as well. 50% of the world's population live within a 5-hour flight of Hong Kong, which means chances are the people you're dealing with will find it a convenient location too. One other very important factor which you might consider is that Indians going to Hong Kong don't require a visa if the stay is for less than 14 days, which can be very convenient, particularly if you need to go regularly or, at the last minute or whatever. That can be quite an important factor. Then looking at why Hong Kong is a reliable venue, I think in people's minds the link between Hong Kong and China is quite a serious issue, but actually it's one that you shouldn't be concerned about at all. The Hong Kong legal system is completely independent. It's economically and legally autonomous from China. It shares the same common law legal history as India does. It's got its foundations in the common law legal system from the UK. It's very much driven by the rule of law. So the legal framework is completely independent of any kind of Chinese influence, which I think is something that's really important, and a lot of people have a bit of a misconception about that. So then within that, you have a very sophisticated and pro-arbitration judiciary and legislative framework. So the Hong Kong arbitration law is amongst the most modern in the world. It's based on the UNCITRAL model law, which many practitioners will be familiar with, which makes it very user-friendly and easy for parties to use. It conforms to generally the best practices which are acknowledged by the international arbitration community. And one of the advantages about the law in Hong Kong is that it's actually unified the laws that would be applicable to domestic and international proceedings. This isn't the case in all places. For example, I believe in Singapore, they still have a separate system, which can create some uncertainty as to which regime would apply to your potential dispute. Also, another advantage of the law in Hong Kong, which is quite different from other jurisdictions, is the law codifies confidentiality. So you can't discuss or publish anything to do with the fact that you're in arbitration proceedings. You can't disclose any of the documents, nor can actually any court proceedings which happen in relation to those proceedings. They have to be conducted in private unless the parties agree otherwise. So that's quite a big thing which differentiates Hong Kong from some other jurisdictions. Plus, the second major factor is the judiciary in Hong Kong is very pro-arbitration. They will only intervene when it's necessary to support arbitration, and otherwise they're very non-interventionist, which is what you want. And then coming to this slide, because of the international commerce that goes on in Hong Kong, and because it's been a centre for these kind of dealings for quite some time, there's a huge pool of experienced, specialised practitioners who are available to help and advise on any dispute that you might have. So as you can see, the numbers are quite staggering for such a small place of the kind of expertise that you can find locally, which would be very helpful. So then in terms of, if you're thinking about arbitration and Hong Kong, why would you want to go to the Hong Kong International Arbitration Centre? We've got three very good institutions standing up here before you, sort of, pleading our case as to why, we would be a good choice. So one of the things about the Hong Kong Centre is, even though it's only now just becoming relevant to Indian parties, it's actually been around for a long time. It was established in 1985, and it's a completely independent organisation. So it's not backed by the government. There's no kind of influence that would come over it. It's completely free to act of its own accord. It's governed by 25 council members or boards of directors, and they're very well-respected legal professionals and business people from around the world. So you're in very safe hands of people who are looking after the institution. There's an international and multilingual secretariat who will be dealing with the proceedings who go through the centre. And then in terms of the facilities, the premises is very central in Hong Kong. It's within 30 minutes from the airport. You can walk to just about every major law firm from the offices. It's been recently, predominantly though, it's a very, very good place for those of you dealing with China. Chinese parties are very happy to deal with the centre. You can see over 50% of the cases had at least one Chinese party. So it's a very good neutral place that's close to the mainland, but yet very separate, but somewhere that the people that you're dealing with will probably feel comfortable going to as well. So then, key features of the rules that the Hong Kong Centre would apply if you go for administered proceedings. Basically, the Centre adopts a really light touch approach, meaning that they will support when necessary, but they really don't want to interfere. They really want to leave the proceedings to the parties' autonomy so that they can really deal with the essential issues and not have to worry about anything else. One of the advantages of this is that it means the centre can really keep its costs a lot lower than those of other institutions. So here's a bit of an outline of how those costs are determined. One thing that's unique to the Hong Kong Centre is that there's a choice for parties as to how they want to agree their arbitrators' fees. Either you can adopt the schedule that is amended to the procedural rules, or you can agree a separate fee agreement with your arbitrators. And this is really beneficial because it really leaves a strategic decision to the parties as to what's going to be most efficient and economical for them. So that's one unique feature of the centre that is quite appealing to parties. Also, the rules are up for amendment at the moment, and the new ones will come into force within the next few months. And one of the new features is going to be a cap on arbitrators' hourly fees, which it just allows for more predictability and manageability in the costs that are likely to be associated with your proceedings. You can see the registration fee, if you want to use the centre to administer your proceedings, is $1,000 US. This is fairly comparable to many of the other institutions in the region. But one of the things the centre also differentiates itself on is that it's a fairly cost-effective organisation. There's just a table up here that you can see comparing how much the fees are in relation to the amount in dispute. So we've got the first column is for the Hong Kong Centre, then after that you have for Kuala Lumpur, then you've got Singapore, Korea, and then finally the ICC. I haven't included anything with the LCIA India because they charge on an hourly rate, so it's difficult to add them into the comparison. But when you look at these figures, you can see that although marginally only second best for a dispute of $500,000 US, very quickly as you go up in amount in dispute, Hong Kong looks like a very attractive option in terms of the fees that you would pay. You'll also see that once you get to a dispute being a value of 50 million, the fee is capped. So it will only ever be a fee of 26,850. So that's quite an attractive feature of the centre, which makes it a very sort of viable and economical options for parties who are looking for where to host their disputes. So really just in conclusion, now that China and Hong Kong are notified as areas where their awards will be enforced in India, there really is a new player in the field. Hong Kong really is a viable option for somewhere that you can host a dispute. It's a very safe and neutral legal environment where you can conduct your proceedings in a very cost-effective manner, but still have state-of-the-art facilities in somewhere that's very easy to get to and is convenient for all the parties who are likely to be involved. So we've already seen an increase in interest from Indian parties. We've already got Indian parties who are arbitrating with the centre, and really it's a trend that we expect to see increase as the years progress. Now that the playing field is a bit more level and we can have our awards enforced, it's really a viable option. So I hope you consider it when it comes up for adding the dispute resolution clauses in your contracts. If this is something that's interesting to you and it's sparked your interest, some of my colleagues are coming back for a roadshow in February. They'll be touring India, and they'll be here on the 5th of February. So just to give you a bit more of an in-depth idea about Hong Kong arbitration. Right, thank you.
Thank you, Ruth. We'll now ask Mr. Vivekananda of SIAC to introduce the SIAC Center to all of us.
Thanks very much, and thank you everybody for staying here until end of day's play. I'm conscious that we're the only people that keeps you from cocktails, so we'll try and keep it short. Just to give you an introduction to arbitration itself, a lot of you will be aware of where an arbitration really begins, and the genesis of any arbitration is really an arbitration agreement. Now, that's generally contained in a dispute resolution clause that is buried at the back of a commercial document, which is 30, 40 pages long. And nowadays, you find arbitration agreements in pretty much every single commercial contract, be it even something that you buy from a shop in a mall will have an arbitration clause. But internationally, of course, it's really the norm for commercial dispute resolution. But I can't overemphasize the need for drafting an arbitration agreement correctly. It's not for nothing that it is called the midnight clause, because quite often lawyers get to it only much later in the evening after they've negotiated all of their commercial terms and don't really pay much attention to what goes into that dispute resolution clause. And that leads to a whole lot of problems. I mean, at the SIAC, we have about 200 new case filings a year, and I can tell you this, that almost 30 to 40% of those cases have problems with the dispute resolution clause. But one thing that I think three of us are really trying to tell you today, and I think Ajay and Ruth will agree with me, is that there's a need to embrace institutional arbitration when you talk about the method or the method of dispute resolution that you choose. And I think Mr. Advani, as a senior practitioner who's had a lot of experience with arbitrations both in India and outside, will endorse that view that institutional arbitration is an absolute necessity. So at the cost of repeating some of the reasons why that is so, is the things that you see on the slide. And why institutional arbitration works better is simply because you have more defined structures to how the arbitral process works. So you have defined costs, you have defined timelines, you have somebody who supervises the entire conduct of the process, you have somebody who can appoint arbitrators, perhaps from a panel like the SIAC does. You have facilities, for instance, for the conduct of the arbitration. There are, of course, very many special procedures that different institutions offer, and I'll take you through some of those that the SIAC has on offer. And there's a general control over the process, which helps to ensure that the two most important factors that you as corporate counsel look out for are taken care of. And those two factors are cost and timelines. How much it costs and how long it will take, I think, are the two primary questions that anybody asks when they're in dispute. Be it an arbitration or be it a litigation, I think that's the first question that you're likely to ask. An added question that comes into play when you're talking about cross-border disputes is the enforceability of any decision that you might get. So an arbitration typically results in what is known as an award. Now, whether an award is enforceable in a particular jurisdiction, I think is crucial, because without that, that award is not worth the paper that it's written on. So that's another important question that one has to look at when you talk about what is important to a corporate user of arbitration. But before I get there, I think there's two things that I just want to briefly mention before I talk about the SIAC itself. One is choosing the right arbitrator. I think that's a very important factor to control cost and timelines. Mr. Advani is, again, somebody who's been appointed as an arbitrator quite often by the SIAC in our cases, and he acts as an arbitrator quite often. And I think that's a very important element to ensuring that you have people who understand arbitration and people who are arbitration practitioners or people who understand the industry that the dispute relates to in order to be able to control cost and timelines in any particular case. Equally, the manner in which the process itself is conducted in terms of the hearings is a very important mechanism for controlling costs and timelines. I think a lot of you would be familiar with it, and I certainly am, having practiced here, is that in, say, ad hoc arbitrations in India, the practice is to have one hearing, you have another hearing a month down the line for somebody to file pleadings, maybe another one 2 months down the line, you may have adjournments in between, and that entire process will result in a staggered set of hearings, say 15 or 16 sittings as they call it, in an arbitration over here. But in an SIAC arbitration, that's not the practice. The practice is to have one or perhaps two tranches of hearings, and the purpose of those hearings is really cross-examination of witnesses and brief oral submissions. And the idea behind that is that having hearings on a regular basis is A, unnecessary. There's no real need for parties on the tribunal to physically meet unless there is a request or there's a requirement to cross-examine witnesses. And all pleadings can really be filed electronically or otherwise. And there's no real need for parties to fly down to a particular place to have a meeting or a hearing on a regular basis. So I think that's a very important element of how costs and timelines can be controlled, is one, appointing the right arbitrator, and two, having a control over how hearings and the entire arbitral process runs. So at the SIAC, a normal arbitration will take about 6 to 9 months if it's a sole arbitrator, perhaps a little longer if you have a 3-member tribunal, so that may extend up to from about 12 to 18 months. But I want to talk about a few procedures that we've put in place to ensure that timelines can be controlled, and another effective means of controlling costs, perhaps by pushing parties towards settling their cases quickly. The first one of these is called the expedited procedure, and as the name suggests, it's a fast-track procedure. Now, any party in any SIAC case can apply to have the expedited procedure used in that case if one of those 3 conditions are satisfied. One is if the sum in dispute is less than 5 million Singaporean dollars. 2 is, of course, the parties agree. Or 3 is in cases of exceptional urgency. The important aspect of this procedure is that it mandates a 6-month completion time from the time the tribunal is constituted to when the award has to be rendered. I'll just give you a couple of examples of cases that we've had under the expedited procedure. We've had about 70 cases now under this procedure, and several of them are cases involving Indian parties. So one such example is this case, which is not a very complicated dispute. The dispute related to a share redemption agreement between a fund and an investor. And the issue in that case was whether the redemption was to be done monetarily or by way of issue of shares of another company of which the shares the fund held. And the dispute was really about a simple contractual interpretation of one particular clause in a contract. So it wasn't a dispute that really required a lot of time or a lot of application of mind on behalf of the tribunal. So parties applied for the expedited procedure to be used in this case. The chairman of the SIAC determines whether a particular case is fit for the expedited procedure. He determined that the expedited procedure should be used, and you'll see the kind of timelines under which that case was completed. And you have an award that was rendered in 6 months, and in fact about 6 months and 20 days since the case actually began at the SIAC. So this is one example of a case that is ideal for the expedited procedure, is that it's not a very complicated issue. It does not involve very detailed issues of fact or many witnesses or expert witnesses that have to be examined. Another example, and we've had several of these cases now at SIAC, are trading disputes, contracts for sale and purchase of iron ore or coal or chemicals, which involve questions about the quality of the shipment itself. So this is a case where there was a coal shipment that was transported from Indonesia to a port in China and discharged there. The only question was whether the moisture content in the coal was in conformity with what was specified in the contract. And all that the arbitrator really had to do was to look at the reports, expert reports, at the port of loading and the port of discharge to determine which one he would rely on to come to the conclusion of what damages were payable. And this was again a case that was completed in about 4.5 months from when the tribunal was constituted. And that's another example of how the expedited procedure works and helps very much to deal with these small contracts and small disputes. Another new procedure that we put in place in our 2010 rules is known as the emergency arbitrator provisions. Mr. Advani was talking about the importance of interim orders, and I think we all understand that litigation or arbitration in India quite often is the fight for the interim order. Once you've had that interim order, the rest of the case is quite often futile, and there may be nothing that the parties really want to pursue thereafter. So the emergency arbitrator provisions are a means of getting or making requests for urgent interim relief before somebody who's specifically designated for that purpose. I mean, typically in India, you would go to a court under Section 9 to request a court to pass an interim order, and that is generally done ex parte and without having heard both parties. Under the emergency arbitrator provisions, you will have both parties heard, and therefore, and thereafter, an order on the interim relief made. I'll give you an example rather than taking you through the provisions. Now, this was a dispute between 2 Indian parties. There was a contract for provision of dredging services in relation to a port in eastern India. Now, the contract had been performed. The party who had performed or claimed to have performed the contract made a claim for monies and had filed an arbitration at the SIAC. In the meanwhile, they said that they had issued a performance guarantee under the contract and that they feared that the other party was going to encash the performance guarantee. and they required injunctive relief to prevent the encashment of the bank guarantee. So they then applied to have an emergency arbitrator appointed by the SIAC. We received the application one evening at about 9:30, and within 24 hours, as mandated by the rules, we appointed an emergency arbitrator, a fairly renowned Singaporean arbitrator. Within a couple of days thereafter, within one day actually, he established a schedule to consider the request for the emergency relief. And then he had a teleconference hearing with a Delhi law firm, a Bombay law firm, and him sitting in Singapore and us sitting in Singapore to hear the parties on the request and to consider his order, and thereafter injuncted the party from encashing the bank guarantee. So then thereafter, once this award was passed, the parties actually settled the case. Another example that we had, again involving Indian parties, was an investment that had been made by a fairly big financial institution into an Indian company. For reasons best known to them, they had not really undertaken a due diligence process. And after about a year down the line, they discovered that there was several fraudulent representations and warranties that had been made, and there was siphoning of funds that was being made by the Indian partner in the venture. And therefore, they filed an arbitration and also made a request for an emergency arbitrator to be appointed to consider a request for freezing of assets. And that was again dealt with in exactly the same manner by the SIAC, with an arbitrator being appointed within a day, and then the request being considered thereafter. The emergency arbitrator was actually challenged in that case by the respondents. That challenge was dealt with again in a matter of 24 hours, and the case continued until the emergency arbitrator passed his award, granting some of the relief that was requested for. So we've had 10 cases now. We've had 11 cases actually. These 10 are from last year. I understand that 4 more have been filed as of yesterday evening. And that is just to give you an idea of the timelines that we've had in those cases in terms of how many days it took to consider those requests for urgent interim relief. And you'll see that 3 of those cases actually involve challenges to the emergency arbitrator himself. And there's also information on whether the relief was actually granted or not. 5 of these cases involved Indian parties, and at least 6 of them settled once the emergency arbitrator award was passed, because that's a good prima facie view, in our view, of what the case is really about and where parties' rights really stand. So that's another example of how special procedures that institutions have can help you control costs and timelines. I mean, to compare institutions across the board, for instance, the ICC and the LCIA don't have an expedited procedure. The ICC has now introduced an emergency arbitrator provision. The LCIA still does not, but the SIAC has these 2 provisions. Just to give you a brief idea of how costs work, which is the other very, very important factor when any of you, I suppose, is in a dispute, is to understand that costing is something that, it comes from this little booklet that you'll see in your brochures, the SIAC brochures, and that's how arbitrator fees and the administrative fees of the institution are determined. The important thing is that all of those figures are fee caps, meaning that when you begin your dispute, you're aware of what your maximum exposure in this case is likely to be, in that it cannot go above this figure. And that's a very important piece of information, I think, to have when you begin your dispute. With an hourly mechanism or with a per sitting fee, it's often impossible to gauge how much this dispute is actually going to cost my company. And that's why we believe that the ad valorem method is a better means of determining costs. The important thing, of course, is also that there is a cost determination process that works in every single case. The formulas that will give you the figures don't mean that that is the fees that is actually payable. We charge deposits on those bases, but the actual determination process, we believe, must be based on an objective assessment of what has happened in that case. You could have a case that is settled in 2 weeks. You could have an award that is rendered, but does not involve a very complicated issue. So the registrar, who's actually sitting up front, makes that determination in every single case on a case-by-case basis. So how complex are the issues? How many witnesses were examined? How voluminous were the documents? Were there substantial questions of law that the arbitrator had to determine? Did he have to look at expert witness reports? And those are the kind of issues that often come up in making a cost determination at the end of a case. So typically an arbitrator or the institution will be paid a percentage of the fee cap that you will find in the schedule of fees in those booklets. So that's how the cost determination process works at the SIAC. So just to give you a comparison between institutions on actual cases that we've had at the SIAC. So for instance, this is a case that was conducted under the expedited procedure. It's about $1 million in dispute, and that's the time spent. So that's how the ICC, the LCIA, and the SIAC will compare. And what I was talking about in terms of the cost determination process is what you see in those two columns at the right in terms of the actual cost and the maximum cost. So the maximum is your fee cap. The actual cost is what you will get once that cost determination process has happened at the end of the case. That's another example with a slightly bigger case. The last thing that I want to quickly talk about is enforceability. And like I said, I think enforcement is crucial to ensuring that your arbitral process works. Finality of awards is, of course, a very important aspect. And in that respect, I think the approach that Singapore courts have taken has been very clear that they will not interfere unless absolutely necessary, and that they will uphold arbitration agreements, and that they will support arbitral processes by not interfering in them. So be it challenges to awards, almost 99% of cases get dismissed at the threshold, simply because the grounds that are prescribed in the model law, much like they are in India, are purely procedural grounds. They don't really permit courts to review awards on merits, and Singapore courts don't do that. And it's therefore also important to look at how enforcement works and what institutions can do that, how institutions can help that process. So you have the New York Convention, which is really the umbrella international convention under which provides for enforcement of arbitral awards in over 140 countries. But different New York Convention signatories still have different approaches and still have national legislations that prescribe different requirements. So we have a process which is called the scrutiny of awards, which is geared towards ensuring that any particular award that goes out from the SIAC is enforceable in the jurisdiction that it goes to. So the scrutiny process requires essentially any tribunal to submit draft awards to the SIAC for scrutiny before it is issued to the parties. And the purpose of the scrutiny is, of course, is to look at the award on form and to ensure that the requirements of the New York Convention are met so that the award is enforceable. So simple things like, has he gotten all the facts correct, the dates correct, the parties, clauses in the contract, the arbitration agreement, whether he's answered all the issues that arise in that case, whether there are contradictory replies to different issues that arise in the case. These are things that are very important. And just to give you one example of a case that we had some time back, was a case that involved a fairly big dispute between two parties and a fairly eminent tribunal that was involved. The award that came in for scrutiny was to be enforced in a jurisdiction that perhaps didn't have the best track record in terms of dealing with arbitrations. So we were fairly concerned that we need to get this right. And the tribunal in that case, matter-of-factly as it were, because they were in London, wrote down at the end of the award, signed on so-and-so date in London. And we were a little concerned because of a judgment that in the UK of the House of Lords, which took the view that an award is made in the place that it's signed. And that's something that was based on an interpretation of the UK Arbitration Act as it stood then. So we were concerned that the place where the award would eventually go in for enforcement might take the view that this is a London-made award and not a Singapore-made award, although the arbitration was seated in Singapore and was administered by the SIAC. So as a result of the scrutiny process, we then requested the tribunal to omit those words signed in London, and they did so. And we explained to them why we thought so, and they graciously accepted to change that portion of the award. So that's just one example of how the scrutiny process can help to ensure that enforcement is always guaranteed. For instance, different jurisdictions have strange requirements or different requirements. For instance, Indonesia has a requirement that an arbitrator himself must register the award in the Central Jakarta District Court for its enforceability. It's not the parties who enforce the award, but it's the arbitrator. So therefore, it becomes necessary for tribunals to perhaps issue powers of attorney to people to enforce the award in Indonesia. And that's something that quite often comes up during the scrutiny process in terms of telling tribunals that that's necessary for enforcement. So those are a few things that institutions do to help cost timelines and enforceability. That's just to give you an idea of the statistics in terms of the number of new cases we've had at the SIAC. The 2012 has, of course, been a record year. And that's to give you an idea of the nationalities of parties arbitrating at the SIAC. In 2011, we had 33 cases involving Indian parties out of a total of 188. And Indian cases continue to be the single largest contributor of cases at the SIAC year on year. Last year, about 25% of our cases involved Indian parties. That's just to give you an idea of the fact that almost 85% of SIAC's cases are international. So I was talking about the arbitration agreement. I'll leave you with this in terms of adopting what is simple and avoids problems. That is, I think, general advice that I can give you several examples of what not to draft, and I'm happy to share that with you personally. But this is perhaps what you can use if you want to avoid common errors. I was also talking about the expedited procedure, and this is something that parties have now chosen to include in their contracts to say that, look, that is a fast-track procedure that we want to adopt for any dispute that arises out of this contract. So that's another thing that we've come out with, which you could consider if the expedited procedure is something that's fit for disputes arising out of that contract. Thank you very much, and happy to take any questions later.
Vivekananda, thank you very much. Just before we call on Ajay Thomas to do his presentation, very quickly, we've seen the growth of international arbitration for two reasons. Largely because obviously foreign parties doing business with Indian companies don't necessarily want to be embroiled in the arbitration process or in the Indian courts, because Indian courts take up the challenges very freely. And now ever since Balco, and there was also before that Venture Global and Bhatia, etc., the law substantially now changed that if there's an arbitration award in a foreign seat, then those courts will have jurisdictions to consider whether the award is appropriate or not. Although ultimately they will have to come for enforcement to India when they're. And those courts, we've seen Hong Kong and Singapore, very, very pro-arbitration, don't set aside 95, 99% of the awards and dispose of them very quickly. With that, we'll call on Ajay Thomas to talk a little bit about what LCIA India does.
Well, thank you, Mr. Advani. Well, ladies and gentlemen, what I'm going to do, hopefully the next 10 minutes, is to give you a brief introduction into LCIA India. And at the outset, I must let you know that there is a difference between the LCIA and LCIA India. Speaking to quite a few of you, during the course of today, I found that the concept that LCIA India is a distinct and separate entity from the LCIA has not crept into, many of you. So you believe that the two organizations are synonymous. So I will try to emphasize on the distinctiveness of LCIA India from the parent body, that is LCIA. Well, let me start off with the LCIA. What exactly is the LCIA? There was one gentleman who thought it stood for the London branch of the CIA. Unfortunately, that is not what the LCIA is. It's an abbreviation for the London Court of International Arbitration. And what exactly is the London Court of International Arbitration? Well, it is one of the oldest and most reputed arbitral institutions in the world, which traces its history back to 1892. So that's almost 120 years of history. And today it's universally known and recognized by its abbreviation, the LCIA. It's a thoroughly international institution insofar as more than 80% of the cases do not involve any UK parties. And the emphasis in the last 25 years, if I may say, is on the I in LCIA, that is international, rather than the L, London. So, what is LCIA India? Well, in 2009, India was chosen as the location for the first independent overseas subsidiary of the LCIA to be established. What's the takeaway from this? That this institution basically has the full support of that gold standard body, that is the LCIA. But at the same time, it's a distinct and separate entity. And I must emphasize this. LCIA India is not a branch office of the LCIA. It's a grounds-up new institution in India with its own set of rules. We do not administer arbitrations under the LCIA UK rules, but under the LCIA India rules. We have a distinct fee structure, which is not denominated in pound sterling, but it's denominated in Indian rupees, which is not a mere rupee equivalent of the UK pound sterling rates. So this is what I really want to emphasize, that LCIA India is distinctive from its parent body, the LCIA in the UK. We were launched in April 2009 at a very simple function in New Delhi, where you had the then Chief Justice of India and the then Law Minister and the grand old man of arbitration in India, a living legend, Fali Nariman, doing the honors of inaugurating this new body. We have a secretariat which is based in India, in New Delhi, at the World Trade Tower. We have a local staff, local registrar and deputy registrar. And most importantly, we've been fully operational to administer arbitrations since the 17th of April 2010, and that is when we launched the LCIA India arbitration rules. A lot of people asked us, why India? If you see, trends, when the American Arbitration Association was looking at Asia, they went to Singapore. When the International Chamber of Commerce, ICC Paris, was looking at establishing a subsidiary or a branch office in India, in Asia, they went to Hong Kong. So why India? Questions which have been asked very often. India, for the following reasons. We believe that India has all the elements to make a success of this venture, that is LCI India. We have a strong and growing economy. Well, I think I must admit that we haven't been growing at the rate that we grew in the early 2000s, but still, if you look at the world economy today, we're still growing at a pretty fast clip. We've got a legal profession and judiciary of outstanding ability. The universal use of the English language, I believe, gives India a big, big advantage. And let's look at it. It's the sheer potential, at the end of the day, for making a difference to the manner in which arbitrations are generally conducted in India today. I think there's a great deal of dissatisfaction with ad hoc arbitration. There are lots of initiatives to improve that. Having a credible international arbitral institution within India is one way of improving the scene, because anecdotal evidence seems to suggest that almost 95% of arbitrations in India are ad hoc arbitrations. So there you see there's a huge potential, for good international arbitration institution within India. Having said that, I thought I'll give you a brief insight into the organization of LCI India. It's a three-tier organization. We have the company. Yes, we are a not-for-profit company established in India under the Indian Companies Act. The company and the board does not have an active role in the case administration. They're purely concerned with the business development of the organization. Then we have the arbitration court. Now, the arbitration court is a body which comprises of 35 members from different jurisdictions. As you will see, it's a multinational, multiracial, multilingual body comprising of 35 leading lawyers from different parts of the world. We have 2 Indian representatives on the LCIA court, that is Zia Modi, the first picture on the top there, and the second picture, that's Darius Kambata, who presently is the Advocate General of the state of Maharashtra. So as you see, people from different jurisdictions. And what is the role of the LCIA court? Essentially, the LCIA court is a final authority for the proper application of the LCIA rules and the LCIA India rules. I must emphasize at this point that the LCIA court serves as the substantive court for LCIA India too. Therefore, it is the LCIA court as a body which controls the quality of the LCIA UK arbitration process. And it is the UK rules, but which are tweaked to suit Indian conditions. And most importantly, from a cost point of view, the rates, as I said earlier, the fee structure of LCI India is denominated in Indian rupees and not in pound sterling, and it's a substantially lower sum. We have the secretariat at the third tier. We're based at the World Trade Tower. We have dedicated administrative staff dealing with arbitrations. I, as the registrar, head the secretariat based in New Delhi. And I believe from an Indian point of view, it's a very geographically convenient location, although I personally do not believe that location matters so much when it comes to administering arbitrations. Parties. Well, there was initially a perception that LCIA India was established only to deal with international commercial arbitrations. But we do administer all kinds of arbitrations, all kinds of commercial arbitrations, both domestic as well as international commercial arbitrations. And the kind of disputes that might come to be referred to as would be technically complex and legally complex cases involving substantial sums in dispute. I think those are the kind of disputes where we as an institution would add a lot of value. And the rules, as I talked about earlier, the LCIA India rules are to a very large extent based on the LCIA UK rules, but we have made changes in points of detail to take into account the interface with the Indian Arbitration Act, to take into account the manner in which arbitrations are conducted in India, and also to deal with certain decisions of the Supreme Court of India. For example, we had a clause, we had an Article 32.6, which was specifically incorporated in the LCIA India rules to deal with the implications of the Bhatia international decision. Thankfully, that decision has been overruled now by the Supreme Court of India in Balco. But then, the short point I'm trying to make is that here are a set of rules which is based on the LCIA, tried and tested LCIA UK rules, but tweaked to suit Indian conditions. And we've also tweaked the fee structure substantially so that it's in line with what Indian parties can afford to pay, or what we believe is more reasonable in the Indian circumstance. I'll come to the cost structure a little later. But then before that, I thought I'll talk a little bit about the concerns of parties in arbitration. Sure. Give me 2 minutes. I'll just wrap this up. Well, the three greatest, concerns in arbitration are the ultimate outcome, win or lose. Well, I think that all depends on your on the merits of your own case. So there's nothing that an institution can do in that regard. How long? Time. An analysis of 100 recent LCIA cases from request to arbitration showed that in around 52% of the cases, they were concluded between 12 months or less, and in 78% of the cases, they were concluded within 18 months or less. So, and we at LCIA India hope to maintain the same, time management statistics with the cases that come to be referred to us. I must admit that it's very early days for us in India. We're just 2.5 years old, so we really don't have 100 cases to give you statistics of how long it's taken, for the few cases that have come to be referred to us till date. Costs, how much? Well, what are the I think it's very important for you to know what are the costs involved in an arbitration. I've just bullet pointed all the various costs that are involved in arbitration. And I thought I'd also share this with you. We talk about comparative costs of institutions. I think this is what is most important to keep in mind. The overall matrix of costs in arbitration. There was a study conducted by the ICC Commission on Arbitration called Techniques for Controlling Time and Costs in Arbitration. And as you see, the statistics are quite revealing. It shows that 82% of the total costs in an arbitration were the costs borne by the parties to present their case. That is, lawyers' fees and expenses relating to witnesses and expert evidence. It was just 16% which were the arbitrator's fees and expenses. And a mere 2% were the administrative fees and expenses of the arbitral institution. So there is a perception in the minds of a lot of people in India that institutional arbitration is expensive. But ladies and gentlemen, in the overall cost scheme, the overall cost matrix, it's a mere 2% of the entire cost of the arbitration. Well, I think I've totally run out of time. All I would like to say is that charges of LCIA India, unlike that of other institutions like the SIAC, ICC, HKIAC, are not based on the sum in dispute. We have an hourly rate. And insofar as we follow the hourly rate, I think it's only the American Arbitration Association which follows the hourly rate. Because our philosophy is that the hourly rate, we believe, is the most scientific way for an arbitrator to charge his fees and also for an institution to charge its fees. Because, let's face it, if you have your fees based on the sum in dispute, a very large sum in dispute is not necessarily an indicator of how much time an arbitrator is going to spend on arbitration. It's not necessarily an indicator how complex the arbitration is. You might have a very high value case, but then it might involve relatively straightforward points of law and of fact. So how scientific is that kind of a basis? So, I mean, I'm not trying to run down the ad valorem system, but all I'm trying to say is that LCIA's and LCIA India's philosophy is that the hourly rates are the most scientific way of actually for an institution to charge its fees and for an arbitrator to charge his or her fees. This is what I was saying. Substantial difference between the LCIA UK rates and the LCIA India rates. I think this is important. I'll just try to end with this slide. What does LCIA India expect to achieve out of this venture? A real contribution to the practice and conduct of arbitration in India, both domestic and international. We hope to add to the existing dispute resolution options that are currently available to parties based in India and those doing business in India and the larger Asia-Pacific region. We're looking upon the opportunity of working with Indian businesses and legal communities in India. And finally, and most importantly, enhancing the attractiveness of India as a seat and venue of arbitrations. I must emphasize that LCIA India has not been established to promote London as a seat and venue of arbitrations. And I think this is extremely important because there is a lot of misconception in the minds of a lot of people that, as to what kind of animal is this institution. And finally, I'd like to just share this with you. I visited a restaurant in Delhi called O Calcutta. I gave my car to the valet parking attendant, and this is the valet parking ticket that I received. And as you see, it's got an arbitration clause. So here, ladies and gentlemen, is an indicator of the sheer potential that arbitration has towards resolving disputes in India, given the great dissatisfaction that we have with our mainstream public justice system. And if I may add, all I'd like to say is that between ad hoc and institutional arbitration, please choose institutional arbitration. You have a plethora of options available, but please choose institutional arbitration. Because in the words of Nani Palkiwala, I'd like to say that, and this is what he wrote in his book, We the Nation, The Lost Decades. Ad hoc arbitration is like a Rolls Royce of 1920s vintage. I'm not sure if you've heard this one before. Stately, because it's dominated by retired judges. High fuel consumption, because the arbitrator's fees are based on the number of sittings, which may be 2 hours or 3 hours. And it takes almost an eternity for completion. Whereas on the other hand, institutional arbitration could be likened to a shiny new Honda Accord. It will take you to the same destination with greater speed, higher efficiency, and most importantly in the Indian context, dramatically less fuel consumption. So ladies and gentlemen, thank you for your patience, and I hope I have been able to convince you that institutional arbitration is the way forward when you are considering arbitration as your means for resolving your commercial disputes. Thank you very much.
Ajay, thank you very much. I know we're all running out of time. So we will take one or two questions, and all the panelists are going to be here later to talk to. Or we will take one or two questions while we have a few minutes.